Good evening, and welcome to Lawyers on the Line. I'm Sean Quinn, a partner with Falsani, Balmer, Peterson, Quinn, and Beyer law firm, and this evening's moderator. Tonight's topic is bankruptcy and foreclosure. In the new economy, it's increasingly difficult for people to keep up with their financial obligations, which can sometimes have devastating legal repercussions. To answer your questions about this topic, I'm pleased to welcome our panelists. Yvonne Novak of the Law Office of Yvonne Novak, and Joe Ferguson of the Johnson, Killen, and Seiler law firm. Yvonne and Joe are ready to answer your questions. Please call 218-788-2844. If that's long distance for you, call our toll-free line at 1-877-307-8762. So welcome, Joe and Yvonne. Let's start with bankruptcy. Yvonne, what are the different types of bankruptcy proceedings out there, or procedures out there?
The types of bankruptcy that individuals can file are Chapter 7, which is a liquidation where your non-exempt assets would get sold by the trustee. However, that doesn't happen very often. And a Chapter 13 where we set up a debt repayment plan with your creditors.
Okay, and then sometimes we hear on the news about Chapter 11 bankruptcy. What is that?
That's for big business.
Okay.
And it's a reorganization of a large business. It's a very different process.
Okay. And then, Joe, I'll ask you about foreclosures. I understand bankruptcy is a federal program. Foreclosures are more state-based?
That's correct.
So Minnesota, Wisconsin would be different?
Yeah, both Minnesota and Wisconsin have statutes that provide a mortgage holder to foreclose their mortgage against the owner of the property and the borrower if they default under the terms of the mortgage.
Okay, and then the process depends on each state.
Yeah, correct. Each state has its own laws regarding foreclosure and the what we call the deficiency judgment that some creditors will go after the debtors for. Yeah.
Okay. So in Yvonne, I'll go back to you. In a bankruptcy, oftentimes we have married couples, or we have people who have co-signed debts. Maybe parents have signed debts for their young adult children. What's the effect of a bankruptcy filing by one of the signers or one of the partners to a marriage versus the other one?
In general, if both people have signed for the debt and only one files bankruptcy, they're going to go after the other person. If they're in a Chapter 13 debt repayment plan, they don't go after the other person. So that may be a point where we'll pick a Chapter 13 plan, a good reason for it.
Okay. And then what about for a married couple? If one spouse is filing for bankruptcy, does it necessarily implicate the other spouse?
It doesn't implicate the other spouse. However, most of the time a married couple has joint debt. And so we're going to end up filing them. And we can't change how it shows up on your credit report. And a lot of times if one spouse files, it's going to show up on the other person's credit report.
Okay, and that goes to kind of a next question, Joe. How does bankruptcy affect one's credit rating or credit report?
The fact that you file bankruptcy will remain on your credit report for 10 years. Okay, now, having said that, the practical effect of filing bankruptcy is that you no longer owe any creditors for unsecured debt. So you become a good credit risk. So it's not unusual for clients, after they file bankruptcy and receive a discharge, to get a lot of pre-approved credit cards in the mail because they know that they're a good credit risk. I know that sounds
it sounds a little counterintuitive.
Counterintuitive was a good word, but it's a fact. And so,
if that happens, are the credit card companies going to say, but we know you filed bankruptcy previously, recently, at least within the past 10 years, so we're going to charge you
that's very possible.
Very high rate.
That's very possible. There are also a number of agencies which will work with you to improve your credit score. You can actually hire one of these agencies to assist you in repairing your credit score.
Okay. Mm-hmm. And then in the process of going through bankruptcy, someone's filed, they've started the process, can they still get credit, use credit cards while the process is going on?
Once a person has come into our office, we're typically going to ask them to stop using their credit cards because they need to have stopped using them 90 days prior to filing the bankruptcy.
Okay.
And once they file, those cards get closed. But
Instantly, that.
pretty much instantly,
Okay.
yes. But as Joe is saying, quite often they get offered new cars.
Okay. And so somebody's thinking about bankruptcy, Joe, they call you up, they come in. Is there, what's the attorney fee charged for hiring you or Yvonne or someone like you guys to help them?
Well, I think most lawyers will tell the clients that the initial consultation is free. We can look at their assets, their liabilities, their financial situation, and advise them if in fact bankruptcy is available to them, and if so, if it would help with their situation. At that point, the fee is determined by the complexity of the case. And I think Yvonne maybe has a little better handle on this. She does more consumer bankruptcies than I do, but.
Well, Yvonne, then let's ask you, is there a typical charge for a bankruptcy? Is it an hourly rate, a flat fee? How does it work?
Bankruptcies are typically a flat fee that you pay in advance. We have to be paid before we get filed, otherwise we get discharged just like the rest of the debtors.
Okay.
And in Duluth, you're looking somewhere between $1,500 and $2,000 as the standard amount that you're going to pay for a Chapter 7 bankruptcy, assuming there's no excessive taxes, no business debt, nothing that makes it very complicated.
Okay. And you said that's for Chapter 7.
That's for Chapter
What
7.
about 13? Is it more or less?
A Chapter 13 is more because we represent the debtor for 3 to 5 years. And
so it's a very long process.
Right, and we're representing them in that bankruptcy during that entire time. So it's closer to between $3,000 to $4,000, but it doesn't all have to be paid up front.
Okay. And so then going back to Chapter 7, you mentioned 13 takes 3, 4, 5 years. How long does a Chapter 7 bankruptcy take?
A Chapter 7 bankruptcy, typically in our office, we can process it in 1 to 2 weeks. We file it, we have a meeting with the trustee in 3 weeks, and then 65 days later, their debts are discharged. So it's about a 90-day process.
Okay, so pretty quick.
Yeah.
Okay, is there court appearances with bankruptcy, Joe?
Well, there's what we call the 341 hearing, which is a first meeting of the creditors conducted by the panel trustee, who's typically a lawyer appointed by the court, and the trustee will meet with the debtor or the debtors and their lawyer, and creditors who want to appear are welcome to come and ask questions that are related to their debt. That's not really a court hearing. It's not convened by the court. There can be court hearings if there are issues involving the value of assets, matters involving the automatic stay, things like that, then you will have to appear in court. But I would say in my practice, perhaps in 1 out of 20 cases, there's an actual court appearance. The other ones are simply meetings with the trustee.
Consistent with you, Yvonne?
Yes,
Okay.
and you do testify at the meeting with the trustee under penalty of perjury. So,
So it's a court-like appearance in that sense.
correct.
Okay. Now, both of you have been using words that those of us who don't practice in this area don't necessarily know what they mean. So I'll ask you some of the basics. The debtor, that's the person who owes the debt, obviously. The creditor is the credit card company or the mortgage holder or someone like that. You talked about eligibility for, filing for bankruptcy, discharges of debts. What do all those things necessarily mean?
Well, in 2005, the law changed, and they put in what is called the means test. And the means test is an income-based test to make sure that people who make too much money aren't filing a Chapter 7 bankruptcy. So it's a test that we have to put in pay stubs and add up their income and make sure that they don't make too much money.
Okay.
Discharge of debt is the debt goes away.
Now, they have things, they might own a house, a car, they might have a little bit of money in the bank, but they owe way more than they can afford to pay off. What happens with their bank account, their car, their house? So.
Well, the homestead exemption, if under Minnesota law, a husband and wife can exempt, I believe it's $390,000
Correct.
of equity in the homestead. So if you have less than $390,000 of equity in your homestead, you can keep your home provided you can continue to pay the mortgage. You can keep an automobile to a certain equity amount, and if you can afford to continue to keep the car. You can keep things like your personal clothes and
Your furniture.
Yeah, exactly.
Okay.
Exactly. And so in Minnesota, we have two different exemption schedules we can choose from, either the federal exemptions or the state exemptions, and they're different. But typically, in Minnesota, it's driven by the equity in your homestead, because under federal law, the equity is so low that unless you've got a lot of cash that you need to exempt, you don't go there.
Okay.
So,
However, the one advantage to the federal system is that we have what's called the wild card, where we can protect toys like ATVs and fishing boats. So
And those are not protected under the Minnesota rules, I
they're
take it.
correct.
Okay. So you have an ATV, fishing boat, another car. Those are going to be sold as part of the process.
Well, if we're under the federal system, depending on how much equity in there, we can use that wild card exemption to protect that asset.
Okay. But then if it's a Minnesota system,
Those would be sold to pay for your debts.
okay. And then how does it get determined? You owe so much money and you owe it to this credit card company, the loan on your car, all these things. How do they divide the money? Whatever little bit is left over, how do they divide it?
They base it pro rata on the amount of claims that are filed.
Okay.
And creditors are so used to getting bankruptcy notices and just throwing them away and not paying attention to me. One of my frustrations is when creditors don't submit claims. And there are times where they don't submit claims when there are assets.
Okay. So then they get nothing.
Correct.
Okay. Now, Joe, sometimes we hear about secured creditors,
Right.
unsecured creditors. What's the difference there?
well, the simple explanation would be if you buy a car and you finance the car, the lender has a hook, a security interest in that vehicle. That's a secured debt. If you own a home and you own a mortgage on your home, the company, the bank, the lender that holds the mortgage is a secured lender.
Okay. And that's why the bank is on your loan title or your car title or your home title.
That's correct.
Okay.
That's correct.
Right. But the credit card, those are unsecured.
Those, yeah, credit card debts are generally unsecured. It's pretty technical, but yeah, they're unsecured.
Okay. Now, a caller, we'll switch gears and go to foreclosure. A caller wants to know, why does it take so long to buy a foreclosed home?
Because it takes so long to foreclose a home. Under Minnesota law, if the lender commences a foreclosure action and does not want to preserve the deficiency against the borrower, the process, I will tell lenders that the process will take about a year, about 12 months, if you do what we call a statutory foreclosure by advertisement. By the time you give the notices required by law, allow the redemption period to run, you're looking at 12 months. And so that lender can't get clear title to that property, for 1 year. Now in Wisconsin, it's a little different. In Wisconsin, you can actually go into court and ask the judge to reduce the redemption period, and typically they'll give you a 4-month redemption period. But even in Wisconsin, you have different procedural rules. In Wisconsin, you're looking at 6 to 7 months before a lender can get good title to that property to then sell it.
All right. And then after the lender gets the good title, then it's just like any other house being sold on the market.
Yes, correct.
All right. Another caller from Duluth wants to know, under what situation would you have to declare personal bankruptcy and business bankruptcy, if such a situation exists?
Well, a lot of times we see small business owners who've gotten over their head with their business debt. And one of the problems with small businesses is they've often asked the small business owners to personally guarantee the debt. So even though they had the protection of the business umbrella, they're personally liable for the business's debt. In most cases, we'll file the individual, not the business itself, because the business's debts don't get discharged. So
Okay.
just the individual gets filed.
What happens to the business debt?
It just goes away because there's no assets left to the corporation.
And the business dissolves?
Correct.
Okay. All right. Another caller says the caller's daughter was laid off 8 months ago, trying to pay the bills. If she declares bankruptcy, Chapter 7, would she lose her home?
In most cases, if they're making the payments, no, they wouldn't lose their home.
Okay. And what, does it make a difference if it's Chapter 7 or Chapter 13?
No, in both cases, as long as they're making their payments, they should keep their home.
Okay.
Correct.
Another caller, this is sort of off topic, but sort of on. So if you don't pay your taxes, state taxes, federal taxes, does that affect your credit rating?
It will affect your credit rating when they file a federal or state tax lien against you personally for non-payment of the taxes. Absolutely.
Okay. And then probably more on point, and that's not in this question, but I think it goes with it. You owe taxes, you don't pay them, I'm going to file bankruptcy. Can you discharge your taxes?
That's a very complicated question.
Okay.
You cannot discharge payroll taxes that you would be liable for as a business owner. Okay. You can discharge income taxes if you meet certain criteria. If you have filed an income tax return, the tax has been assessed, it was done more than 240 days before you file bankruptcy. Okay? You have not entered into a payment plan with the IRS and have done nothing that would otherwise toll the statute. Income taxes are dischargeable in bankruptcy.
Okay.
Student loans are not. Payroll taxes are not. The trust taxes from the payroll taxes are not. Other judgments for things like defamation, if you were involved in a motor vehicle accident and when you were intoxicated and it resulted in a judgment against you, that's non-dischargeable. So there's a laundry list of debts that are simply not dischargeable. Okay. Unless you file an adversary proceeding and ask the court to relieve you of that debt.
Okay. To go beyond the normal exemptions.
Yes.
Okay. Well, Yvonne, I'll ask you about some of the others. One of the most classic examples, as I understand it, that leads to bankruptcy is medical debt.
Correct.
Yep.
Medical debt's dischargeable?
Mm-hmm. Yes, they are.
Okay.
And I just recently have had a rash of people who've been in with $200,000 plus in medical debts. And in Minnesota, you're responsible for your spouse's medical debts. So just because they're only in one person's name doesn't mean that only that person will have to file a bankruptcy.
Okay, so nothing wrong with me, but my wife is sick in the hospital, spends a month there in intensive care, I'm responsible too.
Correct.
And I can't pay it, I'm filing bankruptcy.
That's
Correct.
correct.
Okay. What type of debts have to be listed in a bankruptcy petition?
All of your debts. The debts to mom and dad, because you borrowed money from them, the debts to all your professional creditors, all debts need to be listed.
Okay. And then what some are dischargeable, some are not?
Correct.
Okay. Is there a rhyme or reason as to why some are or are not?
Lobbyists.
Yeah, it's generally a policy,
Yeah.
a policy determination. Now, here's the other counterintuitive part of bankruptcy. You can reaffirm, theoretically, you could reaffirm every single debt that you discharged in bankruptcy.
Reaffirm meaning saying, put it back on my thing, and I want to pay it off.
I want to take responsibility for that debt again.
Okay.
Yeah.
Why would somebody do that? Other than just feeling a moral obligation?
Well, for instance, if you borrowed $10,000 from Uncle Frank, who might live in Chicago and have a vowel for his, in his last name, you may want to say, "Don't worry, Uncle Frank, I'm going to reaffirm the debt that I owe you."
However, your attorney is probably going to tell you that
You're not going to do it.
You're not going to reaffirm that debt because we're not going to go to the work of discharging your debts and have you turn around and reaffirm them all. It makes no sense.
Right.
I mean, I guess, is there any legal reason to do it? Is there any bonus to you saying, you know what, now that I can, I'm going to pay it off again?
There are times it gives you negotiating power with your creditors, particularly like a credit union.
Okay, all right, and you may be able to get a lower interest rate on a credit card or something like that?
Or keep collateral or toys.
Oh, okay.
Credit unions present a real problem for bankruptcy lawyers because credit unions, unlike other financial institutions, cross-collateralize everything. So if you borrow money from a credit union to buy a car, and you've also borrowed on another loan money to buy an ATV or a boat, and you default on one, under the credit union rules, you default on all of them.
Okay. And you
So-
default on your ATV loan, they're going to take your car.
That's exactly right. And so when you're dealing in a consumer bankruptcy with a credit union, you've got to be aware of the fact that they have more power than your typical.
Than a savings and loan or a typical bank.
Correct, yeah, yeah.
Now, mixing the bankruptcy with the foreclosure, you're in foreclosure, but you're not filing bankruptcy, then you file bankruptcy. Can that stop the foreclosure?
Yes, it can.
Okay. What's the process there, or what happens there?
What happens is once you file bankruptcy, the mortgage company, depending on whether they've had the sheriff's sale or not, has to restart the process. So typically it'll buy somebody a couple more months if there hasn't been the sheriff's sale. If there's been the sheriff's sale, then it's probably only going to buy them about another 30 days, because even if there's been a sheriff's sale, the creditor, the bank, has to get permission from the bankruptcy court to go ahead and restart that foreclosure.
Okay. Now, when you say restart it once the bankruptcy's over, or just restart it right when they find out?
They would restart it once they get permission from the court. So it can be before the bankruptcy is over.
Okay. But they have to go to court and say, please let us restart.
Correct.
And that question segues into probably the most powerful tool that the bankruptcy code has, which we call the automatic stay.
Okay. What is that?
The automatic stay is a provision in the bankruptcy code which provides as follows. When a debtor files a bankruptcy petition, whether it's voluntary, involuntary, Chapter 7, Chapter 11, or Chapter 13, all actions against those debtors or that debtor to collect a debt are automatically stayed. It doesn't even require a court order. The filing in and of itself automatically stays every single action pending out there. So what we would typically do if we've got a state law case pending, we send a copy to the court, the clerk's office, and to the attorney that's representing the creditor. Say you can't proceed. You have to go into bankruptcy court and get relief from the automatic stay if you're the creditor to continue to proceed.
Okay.
So, and that's a very powerful tool.
Okay. And this stays lawsuits
Everything.
against the person, any collection efforts by anybody.
They can't sneeze.
Okay, another caller about student loans. 72 years old, just had a stroke, going to a nursing home, still owes some student loans though. What happens to the student loans?
Well,
I suppose just going to the nursing home alone is not going to stop
I'll make
them.
a judgment call on that.
Go ahead.
I suspect that either the servicing agency that's servicing that student loan will give an indefinite deferment, or if that individual chooses to file bankruptcy, the judge would grant a discharge due to hardship.
Okay.
Yeah.
An exception to the usual not dischargeable things.
That's correct.
Okay.
Yeah.
All right. I can't recall if you used this term or not, Joe. Preferential transfer?
Preferential transfer, preferential payment.
What is that?
Well, there are a number of types of preferential payment. The one that Yvonne referred to earlier was if you pay any single creditor more than $600 during the 90 days prior to you filing bankruptcy, that creates a presumption that that payment was a preferential payment, and the trustee can recover that payment for the benefit of the estate. Okay?
So that it can be divided amongst all the debtors.
That's exactly correct.
Or creditors, excuse me.
So any payment made to a creditor within 90 days of filing bankruptcy is presumed to be a preferential payment. You are presumed to have wanted to pay Uncle Frank before you paid Aunt Sally, whatever.
I got you.
Know. Okay. But there are a number of other preferential payments that go back 1 year, 2 years, and even as far into Minnesota law is 6 years.
Okay. We only got a couple minutes left, so Yvonne, can I be discriminated against for filing bankruptcy?
No, you cannot.
Okay.
Job hiring, they can't discriminate for you unless you have some kind of special secret clearance. In general, their employers can't discriminate against you. In general, there's no discrimination.
I learned this after practicing law for 39 years. The state of Minnesota can revoke your contractor's license if as a contractor you file bankruptcy and don't notify the commissioner within 2 weeks of filing bankruptcy, and they can revoke. So
that's a
form
legal
of
discrimination.
It's a
Okay.
form of discrimination.
How long does bankruptcy stay on somebody's record?
10 years.
10 years.
10 years, okay. And this kind of goes along the lines of the preferential transfer. What if you transferred property to a relative more than the 60 or 90 days, you know, a year before, 2 years before, 5 years before?
That would be a preferential transfer like Joe was talking about, where the trustee is likely to force your relative or to approach your relative and say, you have to give that property back so I can sell it, because you should have gotten ownership of that asset. It's treating them differently than everybody else.
Because they are considered to be an insider.
Okay.
Okay.
Yeah. You were going to give the money to Uncle Frank, like you said.
Right.
And so,
Give them
okay.
a deal on the farm.
Okay, fair enough. Well, I guess that's all the time we have. So I want to let everyone know this is the conclusion of the 22nd season of Lawyers on the Line. I want to thank everybody here at WDSE for all their help this season. I want to thank those from my law firm, the staff people who've answered phones this year, and of course all of our excellent panelists that have appeared here throughout the entire season. Remember, you can watch tonight's program and all of the season's shows online with topics ranging from family law and automobile injury claims to bankruptcy, premises liabilities, and so on. Just go to www.wdse.org or www.duluthtriallawyers.com. And don't forget about the volunteer attorney program's Ask an Attorney service. You can call them at 218-723-4005 for more information. I'd like to thank our panelists tonight, Joe and Yvonne, for their expertise, and thank you for watching. We look forward to seeing you all again next season, next year, when the new season begins. I'm Sean Quinn. Good night.